Anyone having business before the King's Justice and the Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Hennessy presiding. You may be seated.
Good morning, all.
Good morning.
Good morning.
Good morning, Your Honor.
Good morning.
We ended yesterday at slide 97 of the demonstratives. I think, Ms. Jones, if you don't mind, we can just do a brief recap before we move on to slide 98.
Sure.
And Your Honor, we'll be looking at volume 5 of the demonstratives compendium today,
Thank you.
and only volume 5.
At only volume 5. Yeah, that would be great. Thank you. So we had left the narrative in the aftermath of the orders of the 7th of January, 1898 from the Board of Arbitration, instructing the parties on the guidelines they should use to compile the data necessary to argue to create an additional award on the Robinson treaties. As there have been some elements of principle which have been decided in the previous awards, but an actual award on a number, dollar figure, an allocation between Ontario and Quebec, which was supposed to be the actual business of the arbitrators, had not been possible because the parties had not been able to agree on how to assemble the data, what was relevant, and how to make the calculations. After receiving the orders of the 7th of January, 1898, Canada and Ontario can resume work on assembling the data that was going to be required to make an award in the Robinson Treaty claims. And again, we have an objection by Counsel for Ontario to the number of people paid annuity by Canada. In their estimation, Canada has doubled the original number of annuitants, and their pay lists are now to be scrutinized. Canada, on its part, And this is Ontario is making this objection to Canada after Canada has left to do their homework following the guidelines from the Board of Arbitration.
Yes.
Got it. Thank you.
Canada is continuing its investigations into Robinson Treaty pay lists, driven in large part by the requirements of the arbitration. There were also other elements in the department's investigations. For example, there had been an earlier investigation in 1896 when it was discovered that people who were drawing interest payments under and land distribution payments under a treaty in Manitoulin Island were also drawing Robinson Treaty annuity payments. And in fact, some of the Robinson Treaty annuitants had moved to Manitoulin Island. So there was a departmental investigation into that, but a great deal of what Mr. McRae, the Inspector of Indian Agencies, was doing was also driven by Canada's perceived need to come up with Robinson Treaty pay lists that it felt it could defend against some of these counterclaims by Ontario. Mr. McRae had been asked to make his reports, some of which had already been completed. I think there was only one outstanding at this time, consistent with the order of the arbitrators on the definition of an Indian, but McRae had refused because in his view, the order would result in many persons being paid who had not previously been paid by the department and had not been regarded as Indians. And on the other hand, there were many people who had ever since the treaty or shortly afterwards, been regarded by the department as Indians and paid annuities and received other treaty benefits, who would be removed from the pay lists. And his advice was that under the orders of the Board of Arbitrators, the lists would no longer represent the Indians.
You can turn to slide 98.
In his final report, which was completed in February of 1899, McCrae recommended that about 1,000 people be removed from the Robinson Treaty pay lists. And I say about 1,000 because the numbers in his report are a little indefinite. He provides numbers of well over 1,000, but there will still be some departmental discretion over whether people are retained on the pay lists or removed. So I've taken a number of about 1,000. And he invented a category which he called non-transmissible title. And those with non-transmissible title, McCrae stated, did not meet the legal requirements for eligibility for Indian status under the Indian Act, but they would continue under his scheme to receive the annuity. However, their descendants would not. So these are people who he considered to be an integral part of the communities under the Robinson Treaty, but whom he recognized under the legal regime of the Indian Act would not actually have qualified for Indian status. And that, again, it's because the Robinson treaties go back to 1850, before any of these the legal restrictions on the Indian Act were in place. He called the invention of the non-transmissible title category a pure act of grace by the department, by which he wished to avoid a situation in which, quote, hundreds of annuitants would have besieged the superintendent general with correspondence, and no little hardship would have been inflicted upon poor people.
Ms. Jones, I wondered if you could take us to your analysis of how 1,000 people were removed by Canada or recommended to be removed from the pay list.
Well, if we could look at that document 2730.
That's JB tab 2730, which is tab 131 in the compendium of demonstratives.
So this is a particular, it's attached to a report on the Port Arthur Indian Agency, which is of course near Thunder Bay. But he appends to that report a summary of all of the reports and investigations he's undertaken into each Indian agency and the pay lists administered by that agency. So this is his summary report, which is dated the 18th of February, 1899. And if we go down a little in this document, we can start seeing some of his numbers at the bottom of page 2. He considers, of the people that are currently being paid Robinson Treaty annuity, that 4,096 are, he thinks, have sufficiently strong title to the annuity that there is no doubt about whether or not they're qualified, although he still says, though in some cases it may be doubtful. He has the next category, 369, person whose title is, in my opinion, so bad that I recommend it should not be deemed transmissible. So this is his non-transmissible title category. And then there was another category, persons whose title, in my opinion, is so bad that I recommend that they should not again be paid, which is on the next page. And this, he classifies 723 current recipients of the Robinson Treaty annuity in that category. But he then goes back to say perhaps 200 or 250 of these who were people recommended to be struck off in my reports of 1897, the earlier reports he's done, he had identified before he thought of this category of non-transmissible title. So it's not clear that all of these 723 people will eventually be cut off. And there may be more than 369 people who will be given non-transmissible title. He has already struck off on the spot in the field 278 people.
Excuse me, Ms. Glasser, what is the significance for you of these specific numbers?
Okay, the reason why I'm bringing it up here with Ms. Jones is she's highlighted it as Canada's effort to reduce the number of annuitants to reach a settlement with Ontario and Quebec.
Maybe you can go to that, Ms.
And
Jones,
my follow-on question was going to be following her review of these numbers to get to that point, Your Honor.
What your conclusion is from these numbers.
This to me demonstrates that the department is feeling some pressure as part of this arbitration process to review its own pay lists and make some changes, remove some people, and not just some people, but really quite a large number of people, maybe up to 20 or 25% of the people who are being paid under the Robinson treaties under its own review process. But Ontario seems to be implying that, in fact, the number is more like 50% should be removed based on its own investigations internally. That's the overall takeaway from these numbers.
And can you link it for us, please, to the reference here in quotes on your slide to the pure act of grace?
Yes, that's he is reluctant to, McRae is reluctant to remove a large number of people. It could be 369, it could be over 500 people immediately from the pay list, although he feels that under an examination in light of current Indian Act legislation, that their entitlement to the annuity would be very difficult to defend. But he is suggesting this transitional category whereby the people who are alive and receiving the annuity would continue to receive it as a pure act of grace by the department. In other words, McRae does not believe that they're under a legal obligation to pay these people, but he is recommending that the department exercise its discretion over the pay lists to make decisions that are more reasonable in light of the actual situation in the Robinson Treaty communities. But he also is saying that those people should not be allowed to then pass on that eligibility for treaty benefits to their children. So it would stop with that generation.
And I found it very helpful when Ms. Jones spoke in terms of percentages, because that gives some context to these numbers.
Right.
And what do you say was the percentage of people from the pay list that Mr. McRae put into the non-transmissible
Well, it's a little fluid, as we've just seen from his descriptions in this document, so it's probably not right to be over precise about it. But he has referred to 369 people he would put in this category, possibly another 250 people that he would retroactively put into that category. The Department of Indian Affairs is currently paying about, I think it's 5,100 or 5,200 people. So that would be, what's the percentage there? That's 10 to 15%,
I've got it. That's helpful.
right?
Uh, perhaps I missed it. I was missing the 5,200.
I think it's at the bottom of that document that we were just looking at the very bottom of the page.
That's two.
Oh, it's 5,694 people who are on the pay lists. You'll notice that if in other documents we're going to refer to, the number of people paid every year is less than that,
Mhm.
because of course some people show up some years and not others. And on the other hand, some people are then expecting payments for the previous year if they didn't come. But this 5,694 number, would actually be 5,691, because he's suggesting adding 3 people to the pay list. That seems to be the total number that he has of people on Robinson Treaty pay lists at this time.
And just to clarify, you referred to both removal of annuitants from the list as well as adding them as a matter of pure grace.
The creation of the non-transmissible title category, he describes as a pure act of grace by the department. We can fast forward on this story to 1917. That's the
We're still on slide 98.
There were extensive removals, and in the pay lists of the time, one will see that a stamp of non-transmissible title next to the names of a number of people on the pay list. And I haven't counted how many people are actually in that category, say in 1899, of non-transmissible title, but I have seen the pay lists and there's a stamp next to it that the department placed on the pay list. So his
Now, sorry,
McRae's,
you started that sentence by saying there were extensive removals.
yes,
Do you include in removals those who were put in the category of non-transmissible title?
I was only thinking of people who were removed from the pay lists in 1898 and 1899 altogether.
Oh,
In other
okay.
words, they were told that they were not going to be paid
So,
anymore.
so those are two different acts. There
Right.
were removals and there were
The creation of
categorization.
this category of non-transmissible title. So in 1917, of course, by then, many of the children of the people who had been assigned this category of non-transmissible title had discovered that they were not, in the eyes of the Indian Department, eligible for Robinson Treaty payments. And there was a fair amount of correspondence and disputes, complaints from those people who couldn't understand why their family had always received the Robinson Treaty annuity payment. And yet the Indian agent was then telling them that they themselves or their children were not eligible for that payment. The recipients found that very difficult to understand. So it created a lot of disruption and certainly paperwork for the Indian Department trying to respond to all of these inquiries. In 1917, then the department just reversed the policy. decided that in its view, it was not worth trying to maintain that category of non-transmissible title. And added about 737 people to the Robinson Treaty Pay lists, mostly children of those with non-transmissible title. They added them back to the pay lists and just abandoned the category of non-transmissible title altogether. So again, this is an indication of the department's discretion and management of this treaty entitlement benefit, which again plays into several other aspects of community life at this time. Whether or not a person is on the pay list can also determine a number of other aspects of their lives. So the department then exercised discretion in this way. And perhaps if we could look at the joint book document 3054.
Right, that's JBD 3054, tab 133 of the demonstratives compendium.
This is a letter which was going to be sent to the Indian agents. It's been approved by the deputy minister, is the note at the top there. Mr. Scott, who by then was the deputy superintendent general, has approved of this letter.
Sorry, and this is tab 133.
Yes.
Thank you.
This letter explains to the Indian agents what the decision of the department is about this category of people. That the department has had under consideration the question of abolishing non-transmissible titles. A decision has been arrived at, and that when making the next distribution of Robinson Treaty annuities, you will therefore pay the living children of those parents whose names are on the non-transmissible lists at the present time or have been on such lists. And then it goes on to go through more specific cases that could come up regarding this. But if we go to the next page, the term used by the Indian Department for this act is that the instructions to the Indian agents are, you should give the Indians to understand this is a matter of grace on the part of the department and that no arrears will be paid. So I found it interesting that there is this reflection almost 20 years apart. McCrae creating the category as a matter of grace. And in 1917, it is also described as a matter of grace to reinstate them in full to the pay list.
Could council, could I ask, or could you ask, is there any indication that the act of labeling someone or placing them in the category of non-transmissible, what is it, non-transmissible title, was communicated to those individuals?
Yes, it was. They found out when they went to be paid by the department.
Sorry, otherwise than at payday?
I'm not too sure about that. You know, I haven't seen, for example, an individual letter that might have been sent, or I think it came up at the time of payment. People would have found out that, for example, their children were not going to be receiving an annuity payment, or in this case, that their children now were going to be receiving an annuity payment, or that they were now to be considered entitled to receive an annuity.
So the way of communicating with the annuitants was through the Indian agent as directed by the department.
Yes.
So if there was going to be a communication to the annuitants that their status had changed, it would have been through the Indian agents as directed by the department,
Yes.
but you didn't see such direction.
We see this direction here.
At-
And we have instructions to the Indian agents after McRae has done his report explaining the concept of non-transmissible title. But I don't believe there was a direct communication from headquarters to the individuals involved. At this time, most of the communication for the communities would have been channeled through the Indian agents.
On direction.
Yes.
Thank you.
And Ms. Jones, before we go to the next slide, just to be clear, the 1917 period in the document you just referred to is after the negotiations between the government and the Award 15.
That's correct.
Why did you think that this 1917 date and document was relevant for your research on this file?
It is relevant in, we'll see that the Department of Indian Affairs, Canada's continued control of and management of these pay lists is very important to Canada. It is very important to Canada for them to defend their administration, control, jurisdiction over this particular aspect of treaty management. And this indicates, is, we'll go through the steps that they took to make sure that jurisdiction was not infringed on by Ontario. This is an example of how it was exercised after the arbitration is over. And we should also know that there was then no further claim by Canada against Ontario or Ontario and Quebec for the increase in payments that would have resulted from adding, first of all, 737 people to the pay lists, which would have been a significant expense. But then if one considers all of the descendants of those children who were added in 1917, it would be quite a large number of people. But there is no then additional claim by Canada regarding the payment for those people. It's considered to be within their discretion, or as they have described it in these documents, as a matter of grace.
And do you know how, if they were not making a claim against Ontario or Quebec, that these additional annuitants would have been paid? From what fund?
They would have been paid from parliamentary appropriations for the Department of Indian Affairs.
When you say it's considered a matter of discretion, you're saying Canada considered it a matter of their own discretion.
Yes.
You can turn to slide 99 if you're ready, Ms. Jones.
So this is the point that I've just been making about McRae and the Department of Indian Affairs wishing to retain the department's discretion over the pay lists. And on the direction of the Superintendent General, so the minister responsible, who at that time was Clifford Sifton, the Indian Department's secretary, J.D. McLean, advises Canada's council in a letter of March 1899 that, at least in the Indian Department's view, it is evident that persons have been paid by the Dominion who do not come within the ruling of the arbitrators as to the Indians entitled to rank as annuitants in the settlement of accounts with Ontario and Quebec. Now, the Indian Department has at this time seen both the statements prepared by Ontario about revenues and expenditures and their own internal reports by McRae about the pay lists. So the council then is instructed that Canada believes or acknowledges that they have been paying people who do not come within the ruling of the arbitrators.
But also that others who do come within the ruling have not been paid by Canada. And in the view of the Indian Department, it would be a matter of great difficulty, if not an impossibility, to prepare an exact statement of persons entitled to rank as annuitants. And in their understated bureaucratic way of the era, the secretary goes on to say to council, mention may be made of the apparent undesirability on the ground of difficulty and expense to all parties of an investigation into the right of each individual to rank on the pay list. An amicable settlement would appear to be in Canada's interest.
Sorry. So the 1917 event is an interruption in what's going on in the
Right.
slides, what's going on in 1898, 1899.
Right.
And you say in the 1898, 1899 investigation, then council is advised that, by the way, we've got people on the pay list that are outside the, is it the entitlement as defined by the act or as defined by the arbitrator?
As defined by the arbitrators.
Right. And that's Council for Canada's advice.
Right, yes. So the compact way of saying this is we don't either want to or believe that we should reconstruct these pay lists under the direction of the arbitrators. And of course, it's Ontario that's pressing Canada, because Ontario, if a claim is made against Ontario for a reimbursement, has said, we want to exercise our right then to review the pay lists. You can't just pay anybody you feel like if we're going to be paying part of the expense. The Department of Indian Affairs does not want that to happen and is instructing its counsel to reach a settlement in Canada's interests.
And Superintendent General Sifton is Minister of Indian Affairs.
Yes.
Go to slide 100.
So these are the statements, 3rd of May, 1898. Which Ontario has submitted to Council for Quebec and Canada. They were worked on together by Canada and Ontario after Ontario submitted them. And in March of 1899, we'll see council sign off on these statements. But again, because these statements are part of the data set that the governments are using to make decisions at this time, I thought we could briefly look at a couple of samples of the statements to see what they look like and what's in them.
And do the statements reflect the numbers on the pay list? Or is this, are we on a different topic?
Well, that's a good question. Because the annuity payments and the cost of making those annuity payments are going to come out of, are going to be considered as part of the revenues and the expenditures. So there has not yet been an agreement on exactly how many people should be paid, what those payments should be. But there has been some agreement on the excess of collections over revenues and for what years those excesses exist.
Should we pull up tab JBD tab 2660? Which is tab 135 of the demonstratives compendium.
So this is the summary sheet for Lake Superior. Statement of all collections from the territory and of all expenditures. from 1850 to 1892. This is a statement submitted by Ontario, but on which Ontario and Canada have then subsequently done work to verify the numbers. So you asked about the annuity payments in particular. There is a column which is 5 from the right, which says payments to Indians. And that column, you'll see, has $2,000, I believe, all the way down. You can scroll down.
With 8,000 at the top.
Pardon me?
8,000 at the top, yes, for the initial payments in 1850. So the only amount that's on these statements then is the amount that's covered by the sum that was capitalized in as of Confederation. What we've been calling the pre-augmented or fixed annuity.
So you're saying when I go to column number, if I don't count year, column number 5, says expenditure and I see 8,000, I know that to be the,
So that's the initial payments made at the time of the treaty, 8,000, so it's more. And then after that, it's 2,000 a year.
Your Honor, just to make sure the record's clear, I think Ms. Jones had directed the readers to look at the 5th column from the right to start, which is payments to Indians. Ms. Jones, please correct me if I'm wrong.
Yes, that's correct. Yeah.
thank you. So it's just a coincidence that it's also in the 5th column. So what is being recorded is, oh, so that was 1850. So that's the actual payment.
Right. Now, it does say all expenditures and all collections, but I mean, that's not quite accurate. These are categories which have been set out by the arbitrators in their order of January 1898. There could well be other revenues and other expenditures. The headings don't quite align with the order of the arbitrators, but they are broadly similar.
And Ms. Jones, if I may, is it just for the period between or up to 1892 that this document refers to?
That's right, because
So-
that's the
Go ahead.
mandate of the arbitrators, is to go up to the end of 1892.
So we are not seeing any increased payments reflecting changes to the pay list.
That's right. This is just the amount that's covered by that initial capitalized amount in 1867.
Right. That's the amount that is generated by the capitalized amount.
Right.
But is it the amount actually paid?
No,
Aha.
not at all. Not after 1875.
And do we see what's actually paid somewhere?
We see it in some of the records of the Department of Indian Affairs that we'll be looking at, but not on this statement.
Can you explain why you've referred to this particular document at this time?
I think it's just instructive to look at this data set, which underpins the 15th award, for example, and was the basis on which both Ontario and Canada were making decisions about what to include in the 15th award, which is the one that sets out the respective responsibilities of the province of Canada and thereby Ontario and Canada regarding
the payments under the Robinson treaties.
Are we done with this document?
Could I ask another question then? You said, I thought, perhaps Ms. Glasser asked the question, that Canada was not making a claim for those Indians, I say in quotation marks, for those Indians who perhaps should not have been on the list. But were they hiding the fact that they were paying them? Or what is going on here?
Well, at this point, as between the two governments, you see, we have a privileged position where we are because we can see the preparations being made by each government, the internal discussions that each government is having. As far as where that intersection is at the two governments at the time, we have Ontario saying, we think you are paying far too many people.
Mhm.
Canada has looked at their own pay lists and has not yet disclosed and does not want to disclose to Ontario how many people they're paying and why. So what Canada is saying is fundamentally, Ontario, we don't want you to start getting into the data from these pay lists and questioning our decisions and potentially interfering in who gets paid and who doesn't. They have not disclosed that internal information to Ontario. They have their own, as we've seen, they have their own internal advice to their council about what they think their position is. They feel vulnerable on this point, but they don't want Ontario to be able to get access to the information about exactly how many people are being paid.
Is there any benefit, Ms. Jones, at looking at the other document you had mentioned for the slide?
Just go down to the bottom of this one first. We can just confirm that this is the statement. Oh, it's the bottom of the page
chart.
with all the numbers on it. It's signed in March of 1899 by all three council to show that they have agreed on these numbers. I just thought that was an important thing to point out. It will underpin the 15th award.
Understood. Do we need to go to 2663?
I think it might be useful because it shows what was drawn out of this great big statement with all of these numbers year by year on it.
Okay, tab JBD 2663, Compendium of Demonstratives 138.
This is essentially the summary document based on all of the figures we saw in the big sheet there. This is for Lake Superior. It was developed in April 98 and was sent to the other parties in May of 1898. It is called a tentative statement of the periods when Ontario and Quebec become conjointly liable to pay increased Indian annuities by the Lake Superior Treaty. And as regarding the number of Indians, the numbers of Indians assumed to be paid are in accordance with Dominion allegations of payments and are subject to proof that such Indians are entitled to the increases. If we just take a quick look at what's in that document. Here's there's a column for the excess of expenditures over collections.
Which column is that on the chart?
That is the third column from the left. There's also an indication in the rightmost column of
the numbers paid under the treaty for this early period, which is given as 1,240 Indians, which is the number in the treaty. So there are years of surplus being noted in the column second from the left. There will be a number there which indicates a surplus. Now, this is calculated in the way that was set out in the third award, which means that if there is a surplus in 1 year, it can be carried forward into the next year. But the surpluses can't be carried backward.
Sorry, that's the column immediately after the year or the next one?
So the column immediately after the year is called the amount of collections in excess of progressive expenditure at periods when the Indians can be paid without incurring loss.
And you say, and you call it the surplus?
Yes.
Okay.
So Ms. Jones, when you refer to on the third last line of your slide of 100, slide 100, calculated by the method set out in the third award, that's the third column on that document. Can you explain that again, just to make sure we understand?
The third award stated that this calculation was to be made by, first of all, ascertaining the balance of revenues and expenditures in any 1 year. And then to, again, that if there was a surplus in 1 year or a deficit, it could be carried forward into the subsequent year. But a surplus in 1 year could not be used to give an increased payment in a previous year. So these numbers are cumulative over time, the balances between expenditures and revenues. And again, these are the expenditures and revenues as set out in the orders of January 1898. If we go a little further down on the page, we'll start to see the numbers of the surplus of expenditure over revenue increase. It goes down a little and then up again. If we go on to the next page, there are years in 1872, 1873, and 1874 that show a surplus. The numbers for 1872, 3, and 4 for the number of Indians paid are still 1,240. This is before the augmentation. And then after 1875, the numbers on the deficit column, generally speaking, get bigger and bigger. If you go right down to the bottom, that's 1889, 1890, 1891, 1892. There is some fluctuation, but at least according to this table, there is that excess of expenditures over collections for every year after 1874.
And you're not purporting to analyze these numbers or verify?
No.
them?
I mean, obviously, it would be very difficult to verify them now. The people at the time had access to their own books and records, some of which we may have at this point, but I wouldn't be guaranteed that we have everything that they would have used. And of course, this is all within the framework that has been worked out in these arbitration awards.
I have two questions on this. One, is whoever created this document, are they purporting to indicate any number for how many people paid after 1875?
No,
And that's their agreement, because this is a signed off document, I think you said.
yes, this one is signed as well. If we go a little further down on the screen. I think it's actually the next page. And the covering letter indicates that this statement is supplementary to the large sheets. We've just seen one of the large sheets. Shows the balances in the respective years for which the provinces are liable to the proper number of Indians. So that's not yet agreed.
Sorry, what are you reading from
This
the
is the
top?
last page now of that document, and you have to turn it sideways.
Got it, thank you.
In the several years shown therein. The figures in red ink, not final, which I think are to, unfortunately, we don't have this one in color, so it's a bit of a problem. But it is shown as being endorsed by Council for Ontario, Quebec, and Canada on the 23rd of March, 1899.
So that was my first question. So they don't purport to articulate a number, and then it says they have verified these reports, or did you say that?
The Canada and Ontario accountants worked together to see if they could agree on those numbers.
But are they verifying the number of payees?
No,
So they work together to come up with dollars in, dollars out.
right. To see if they could agree on those numbers.
Okay.
And of course, I've shown the one for Lake Superior because that's the one we're most interested in right now. But the Lake Huron calculations are relevant to the overall pictures. So we won't pull up those statements, but we will come back to Lake Huron as part of the overall settlement.
Go to slide 101.
So while all of these documents then are coming together, we have McRae's reports, which are in completion in January and February of 1899. We have these statements that you've seen of the revenues and expenditures, which have been examined by Canada and Ontario. And the chief accountant of the Department of Indian Affairs in January of 1899 is trying to offer advice to the department on what comes next after all of this work has been done. This is a memorandum which doesn't have a particular recipient, but it was circulated to other officials in the Indian Department. Mr. Scott, the chief accountant, in January of 1899, notes in an internal memo that based on Ontario's statements in the Robinson Superior Territory, quote, "It is plain that since 1874, it has not been possible for the provinces of Ontario and Quebec jointly to pay the Indians without incurring loss any increased amount." Scott expresses the view that, quote, "There is no likelihood that a surplus will occur in the territory covered by this treaty for some years," end quote, and asks whether Canada would continue to pay what he calls the full annuity of $4, because in his view, no obligation devolves upon the Dominion government to continue this payment. In other words, in Scott's opinion, the question is open as to whether the criterion in the treaty has been met to pay $4.
So this question was referred to, this memo was referred to the department's law clerk.
Sorry,
Who-
sorry to interrupt, Ms. Jones. There's a lot of ambient noise. I can't hear you very well.
The question was referred to the department's of Indian Affairs law clerk, who indicated it was really a decision for the minister. In other words, in the law clerk's opinion, this is not purely a legal issue. It is an issue which should be decided by the minister responsible for Indian Affairs. The minister, Sifton, made the decision to continue the payments of $4 in both the Robinson Superior and the Robinson Huron Treaty territories, even if the amount in the Robinson Superior Territory was not recoverable from Ontario or the province of Canada under this arbitration framework in which they were working.
Do you know whether this decision of Minister Sifton was carried out?
Yes. Now, again, that Minister Sifton was given a memorandum from Mr. McRae, who had been making all these investigations into the Robinson Treaty pay lists. And his opinion, which he offered to Sifton and Sifton accepted, perhaps we could look at the document because I don't have it on the slide.
It's
It's in my report.
JBD 3023.
Yes.
Compendium demonstratives, tab 143. Can you remind us what we're looking at here?
This is a memorandum from Mr. McRae, the Chief Inspector of Indian Agencies, and the author of all of these reports on Robinson Treaty pay lists for the Superintendent General as to whether the Canada should continue to pay the Robinson Superior Treaty beneficiaries $4. And he refers specifically to the decision of the Board of Arbitrators and in the context of the settlement of accounts of the province of Canada. McRae also refers to the opinion that we've seen earlier from Mr. Blake, the Minister of Justice in 1875, that increased payments should be made in both treaty areas because both treaties are similar, were made with the North Shore of Lake Superior and Lake Huron. And this was concurred in by the Superintendent General of Indian Affairs. Again, we've seen that memorandum associated with the Order in Council about the augmentation of Robinson Treaty annuities. So McRae is going back over all of these previous opinions when the augmentation was made. If we could go to the next page. He then refers to the Order in Council. And in McRae's view, made it clear, the Order in Council authorized the augmentation and made it clear, quote, that the intention of the government of the day was founded upon the principle that it was proper policy to pay the Lake Superior and Lake Huron Indians alike, irrespectively of any question as to which of Her Majesty's governments in Canada would ultimately have to bear the burden of the payment. And then if you continue to move down through this document here,
So what is the point of that sentence? That they pay them alike?
yes, and to go ahead and make the augmentation before a determination was made as to who would ultimately pay.
Right.
So that
So
was
notwithstanding who pays, the importance is to maintain this principle that they be paid alike.
Yes.
Thank you.
Or to be paid, in fact, at all. They don't,
Paid,
the
period.
increased amount, That let's just go ahead and pay. This was the decision made in 1875. If there is a dispute between governments, we can address that later. But we, Canada, are not going to delay the payment on that account.
All right, that's what I had understood from when we heard the evidence on the decision, but is there something in addition being articulated here?
It's given as a reason to continue to pay an increased annuity in the Robinson Superior area, even though these statements that we've just seen might suggest that the clause in the treaty regarding augmentation has not been met. And it would then be not possible to claim against the province of Canada,
Mhm.
possibly, for that augmented payment.
And this letter is being written in what year?
This is April of 1899.
Thank you.
The McRae's ultimate recommendation is that the people in Lake Superior should continue to be paid the $4. If we go over to the next page, we can see some of his other reasoning. That the peacefulness of the Lake Superior Indians was of just as much importance as that of the Lake Huron Indians. And as to the rights of use and occupancy of territory, what each of these sold to the Crown was of equal value. So McRae's view is that it's in both areas, Indigenous people entered into a treaty, and what they offered in that treaty was of equal value to the Crown.
I just have to find in the text where you are.
That is, I think, the third page of the document in the paragraph near the top.
Thank you.
Ms. Jones, can you carry on? It is due to that.
Yes. Right, due to that, he's referring to two treaties being made instead of one. The Lake Superior Indian chiefs trusted in the faith and benevolence of the crown, and the Lake Huron chiefs, trusting less, were disposed to attempt to drive a harder bargain. Remember, McCrae wasn't actually there at the treaty, but this is his understanding of what happened. He says, McCrae goes on to say, it is due to that and to the fact that one part of the surrendered territory has produced more revenue than the other part, that thoughts of discrimination between the Lake Superior and Lake Huron Indians have arisen. But McCrae is saying that that's not the right approach to take in this case, that Canada again exercised its discretion in 1875 to make payments regardless of which government was going to ultimately be responsible for the financial burden. And here again, he's recommending that for all of these contextual reasons around the treaty, that Canada essentially not be bound by the claims in the arbitration process and continue to make an augmented payment to the Robinson Superior Treaty people, even if this whole arbitration process has produced documentations that would indicate that perhaps the $4 was not generated by the territory in that time.
Reflecting it back to why we pulled up this document in the first place, I had asked the question about how did you know that Minister Sifton had carried out the decision to pay $4 even though there would be no ability to recover against the provinces? And what's the answer to that question?
The payments were continued to be made at the level of $4. We do see at the very top of this memorandum that, oh,
Your call.
I'll ask the question again.
okay.
It was, I'd taken you to this document, which you've just provided some helpful information about the context. And how did you know, as you stated here, that this document resulted in Minister Sifton deciding to pay the $4, even though they would not recover the money from the Crown for the Superior Treaty communities?
If we look at the very top of the document, on the first page, this is the handwriting of Mr. J.A.J. McKenna, who is the Clifford Sifton's private secretary. And he has written across the top of the document, Minister approves. We also know that the payments were continued to be made at $4 for the Robinson Superior Treaty people after this decision.
Independently by Canada.
Yes.
I just want to. Minister approves is the
Right.
reference you made. And is this did we call this a letter?
It is a memorandum for the Superintendent General from Mr. McCrae.
Can you remind us again who Mr. McCrae is?
He is what is called the Inspector of Indian Agencies and Reserves, which means he has a very broad mandate to investigate any problems or issues in the administration of Indian affairs and to make recommendations to make sure that departmental policy is being applied in a consistent way across all of the different Indian agencies. He's essentially a person who, as we've seen here, sometimes takes on special assignments for issues addressing the department. And he is of a sufficiently senior classification that he can prepare a a memorandum directly for the Superintendent General. So that gives you an indication of his seniority in the department.
Your Honor, I'm noting the time. I don't know if it's a good time for the morning break.
Why don't you tell me if it is?
I'm looking at Madam
Are
Reporter.
you halfway through?
No.
What you have to do today?
I'm not halfway through.
All right, should we go to 11:30?
Sure.
Okay, let's try that.
Okay, we'll go to slide 102.
Mr. Scott, then, the departmental accountant, then turns his mind to again, the data presented in the statements that we've seen, to try to find a solution for the department for some of the issues that they're facing in the arbitration. He prepares 2 memoranda, and the intent of the memoranda, in his own words, is, quote, to promote a settlement of the account between the government of the Dominion and the old province of Canada, as represented by the provinces of Ontario and Quebec jointly. So these are memoranda which are prepared explicitly for use in the negotiations and the arbitration process that the Canada and Ontario are involved in at the moment. He writes 2 memoranda. One covers the Robinson Superior Treaty Area and the other covers Robinson Huron. In Scott's view, in Robinson Superior, the liability of the province of Canada for the years 1853, 54, 56, and 1872, 1873, and 1874 was, in his words, conceded. The outstanding issue is to, again, in his words, to fix the number of Indians for whom in each year payment is properly claimed. And he observes at this point that the Department of Indian Affairs did not have the actual physical pay lists for much of the 1850s, because he doesn't seem to know this, which surprises me, but the Hudson's Bay Company were making the payments at that time. And in fact, the pay lists for the Robinson Superior area in the 1850s are contained in Hudson's Bay Company records. However, Scott goes ahead to estimate what he calls a fair number of recipients to arrive at a sum that could be considered outstanding for arrears. There were also pay lists missing for 1873 and 1874. And Scott recommends taking an average of the numbers of people that they know they paid, making some estimates for the missing pay lists, and putting all of these, what he would call fair numbers, together to calculate a total amount of arrears owing. So this is what they're going to be claiming against the province of Canada. He doesn't provide any estimate or any provision for future payments of increased annuities to Robinson Superior beneficiaries, because in his view, after looking at these statements that we have just seen ourselves about the revenues and expenditures in the Robinson Superior Territory, in his view, it is unlikely that there will be, in the foreseeable future, an obligation to pay increased annuities for the Robinson Superior people. So he ends his consideration for the claim to make against the province of Canada in the period leading up to December 1892. He doesn't try to go any further than that.
And turn to slide 103.
A few weeks later, Mr. Scott completes a second memorandum that deals with the Robinson-Huron Treaty. And again, Scott finds that the department doesn't hold a complete set of pay lists for the Robinson Huron Treaty payments. So he attempts to calculate some kind of a number. Now, what he's trying to come up with is a number that Canada, through its council, can take back to be negotiated, to be charged against the province of Canada. In the context of trying to come up with these numbers, Scott writes in his memorandum that this settlement must finally rest on compromise. It would not serve the ends in view, end quote, for Canada to insist on including everyone on the pay lists. Scott then goes back to McRae's reports that we've seen earlier this morning and attempts to set a proportion of persons paid who, in Mr. Scott's estimation, were persons, quote, Ontario and Quebec cannot be asked to pay, end quote. Scott estimates this proportion at 20%. He reduces the number of people the department has actually paid between 1873 and 1898 by that proportion, and then arrives at a figure to claim against the province of Canada. He then takes the reduced number for 1898, rounds it down again, and sets 2,800 people as, quote, the number fixed as the limit beyond which the responsibility of Ontario and Quebec jointly should not go, end quote, for a capitalized amount, excuse me, for future payments. So looking at both of these memoranda, it's fairly clear that Scott's numbers don't represent an actual count of every person on the pay lists. They are numbers of people who, in Scott's estimation, represent a figure that can be claimed against the province of Canada. He knows, and in the memorandum, he indicates that Canada is actually paying many more people than what the claim is going to be. But he identifies a number for the purposes of settlement in both treaty areas for which he thinks it is reasonable that Ontario and Quebec jointly could be asked to pay.
Go to slide 104.
The
Is
minister,
it, sorry, is it could reasonably ask to pay or could be reasonably asked to accept?
well, at this point, the liability has been established against the province of Canada.
Yes.
Canada is deciding how much money to claim.
Yes.
Scott has said, based on these factors, this is what I think would be a reasonable amount to claim against the old province of Canada for the arrears of these annuities, and as well in the case of Robinson Huron, for a future amount to be paid to cover the increased annuities. He doesn't do the same for Superior because, in his view, after looking at the statements, he thinks that there may not be any future obligation to pay an increased annuity there.
And that, those words, any future obligation to pay an increased annuity, any future excess of revenues over
Right.
expenses.
And remember, this time, the minister has already decided, however, that the department will continue to pay. Canada will continue to pay that increased annuity regardless of whether or not it can claim against the old province.
And one more question, when you say that he knows that Canada is actually paying many more people than what the claim is going to be.
Yes,
Claim against the provinces?
the claim against the provinces, yes.
Thank you.
So we're on slide 104 now.
Then the minister, Mr. Sifton, instructs the Secretary of the Department of Indian Affairs to forward these two memoranda prepared by Mr. Scott, the accountant, to Canada's council. And the covering letter recommends these memoranda as, quote, having as their object the promotion of a settlement between the Dominion and the province of Canada in relation to these treaties. The terms of settlement therein recommended would be quite satisfactory to this department. So this is the instructions again that they're providing to their own council. If you settle for these numbers, we would be happy with that. The Canada's council replies that in his view, Scott's methodology was, quote, the best that can be done to date, end quote, and proposed drawing up what Hogg called an arbitrary statement of the numbers of Indians, which the Dominion says are entitled to participate in the increased annuities, to submit to Ontario and Quebec.
You said earlier, Ms. Jones, that the information regarding the rounding and arbitrariness of numbers had not been shared with Ontario. At this stage, had anything been changed in terms of the information conveyed to Ontario?
The proposal is to submit Scott's memoranda to Ontario and Quebec. This is what Scott, Mr. Hogg, the council suggests.
And would that provide the information about the arbitrariness of the numbers as well?
Yes,
You can go to slide 104
Did you get an answer to your first question?
about the information being disclosed with Ontario?
Right.
Yes.
Hogg is proposing to send these memoranda that Scott has prepared over to Ontario to say, here's our proposal for a settlement.
Mm-hmm.
What do you think about that?
The question which was asked, and I'm interested in this answer, is that the rounding and the arbitrariness of the numbers had not been shared at this point with Ontario.
Not yet.
And I thought the question was, at this stage, had anything changed? And you're saying, so this is the first time, yes, something's changed. By sending these memos, they are disclosing that their numbers are arbitrary and rounded.
Yes,
They're disclosing that to Ontario.
yes. So we'll see in the next slides what actually happens.
Sure.
Slide 105.
Forward. I've already referred to this. On the 23rd of March, Council for Canada, Ontario, and Quebec sign off on all of the statements of revenues and expenditures. The statements were then filed with the Board of Arbitration. Mr. Hogg writes to Mr. McLean on the 3rd of May, the Secretary of Indian Affairs, reporting that, in Hogg's words, a settlement has been practically arranged respecting the number of years in which increased annuities will be payable, and also the number of Indians who will be entitled to these increased annuities. However, Mr. Hogg recommended that the number of beneficiaries to be used in calculating future payments, this is for the Robinson Huron area, be reduced from 2,800 to 2,650. So he then, this next sentence seems to imply that he has not actually sent over Mr. Scott's memoranda, because he says, it may be that the provinces will object to so high a number as 2,800. So Hogg recommends reducing the number yet again for the future payments.
So now I'm back to that original question.
Yes, if I may, Ms. Jones, the intention was to send the letter that Scott had prepared.
Yes,
Whose
And
intention?
Hog's intention.
yes.
So Council for Canada says, let's send these memos to the other council. And it appears,
In May, he is writing to the Department of Indian Affairs. The letter seems to imply that he hasn't actually tried out he may have tried out the dollar figures for the arrears, because he says a settlement has just about been arranged. But he is not sure yet that the provinces would agree to future payments being set at a number as high as 2,800.
which suggests that he has not sent the memos.
I think that's
At
what
all.
that suggests.
Okay.
Although I think he has shared the numbers that Scott has generated for the arrears of annuities.
His final instructions. He's got instructions
Right,
on on a dollar figure.
right.
So at this point in your evidence, I'm not sure what the next part of the story is. You say there has not been sharing with Ontario on how the numbers were arrived at, how they were rounded off, or that they're arbitrary. That has not been shared. Is that your view as of
I think
slide 105?
At this point, Hogg has shared information on how the arrears would be calculated. In other words, we're claiming for this many people at this amount and these years. As he says that a settlement is close. But it seems to me that he has not yet proposed or shared the information about the future payments that could be made in Robinson Huron area, because it appears from this letter, he says it may be that the provinces will object to so high a number as 2,800 to be paid in the Robinson Huron Treaty area.
I'm just going to ask Ms. Glasser, is this an important point for you?
Yes,
Okay, so I don't understand it.
It's
Just so I'll just leave it with you.
right. It's it becomes relevant later on because the settlement to be made for future payments
Mhm.
in the Robinson Treaty area ends up being applied in the Robinson Superior Treaty area.
Okay.
So that's why we're still talking about these people in the Huron territory.
No, what I was asking was the question that you originally asked.
I understand the question. Your
If
Honor.
that's an important point for
Yes.
you, the timing of sharing of information, the type of information sharing, it's not clear to me.
Yes, Ms. Jones, to your best information, was any of the treaty pay list information that Ontario had been asking for been shared with Ontario?
With Canada, or Canada's information.
Yes.
Right. Canada had not been willing to share treaty pay list information with Ontario. In fact, had resisted it very strongly up to this point.
Up to May 1899?
Yes.
Okay.
And just to give an idea then, if future payments are being claimed for 2,650 people, according to Scott's own calculations, they were actually paying in the Robinson Huron Treaty area about 3,360 people. In 1892, which is the last figure that I could find easily, the amount of the money that was spent by Canada on annuities for both treaties implies about 5,300 payments. We've also seen a number for both treaties of about 5,600 people actually on the pay lists from McCrae. But Hogg is recommending that at least for future payments, that Canada only claim for enough money to pay 2,650 people.
And also, if I can, on your clarifying answer to council about Canada had not been willing to share a treaty pay list up to this time, had resisted strongly. And do you say that is other than Hogg, I'm looking at slide 104, proposing that Scott's memorandum be shared? Which may not have been done, but Hogg is proposing that.
Right. Hogg is also proposing, as he says, drawing up an arbitrary statement of the number of Indians,
Yes.
which the Dominion says. So he may have done
But-
that.
But he's proposing to submit it with the memorandum, which suggests to me, pick a number, but I'm going to send to them, or I propose to send to them, the memorandum which tells them that this is arbitrary and rounded. And there's some explanation of what's been going on
Mhm.
on Canada's part in those memos.
Yes.
Okay.
I haven't found in any Ontario-related records these memoranda from Scott in their entirety.
And that's why you're saying that was the expressed intention.
Yes.
Your Honor, I believe we're at 11:30 now.
All right. Let me just catch up for 1 second. We'll take a break.
Sure.
Okay. Let's take a morning break. Just before we leave, I'll go forward.
Members, you may be seated.
You understand we'll go for a half an hour. And we're just doing a brief recap of slide 105.
Right. So where we left off at slide 105, we have Canada Council writing to the Department of Indian Affairs, saying we have a settlement is close based on the numbers that you provided to me. But as far as future payments go, I think we're going to have to lower our number further to 2,650. Whereas in the Robinson Huron area alone, the department was actually paying 3,360 roughly people. In 1892, the Indian Department had spent an amount of money on Robinson Treaty annuity payments for both treaties, implying about 5,300 payments.
Remind me, the 2,800 proposal was for both.
Was just for Huron,
Oh,
just for Huron. But that had been Scott's, take 20% off, do an average, maybe round down. He's thought maybe 2,800 would be a number, in his words, that Ontario and Quebec can be asked to pay.
Sorry, 2,800,
That was.
as opposed to 3,360.
Yes.
Thank you.
And so now Council for Canada are saying, I think we have to lower it again. I think 2,650 is going to be the number that Canada and or Quebec and Ontario will agree to. I could try to get them to agree to this lower number. So then we go on to slide 106.
Ms. Jones, before you move on there, I just have a question. So independent of what Canada was pursuing, was Canada continuing to pay for any discrepancies in the numbers.
Yes, I mean, they're paying, that some people have been removed from the pay list after the McCrae investigations. But they are continuing to pay $4 to people in the Robinson Superior Treaty Area by decision of the minister.
That's the approved document from Minister Sifton we saw earlier.
Yes. And they are continuing to pay this larger number as well in Robinson Huron.
Go to slide 106.
Oh, excuse me, I've just had a technical glitch. Can you take a minute, please? Thank you for that. Yes, thanks.
Ms. Jones, you were just on slide 106. I think at the beginning, taking us through this slide.
Yes, so now this is a letter from, again, from Canada's council to the Department of Indian Affairs in May, early May 1899. And in this letter, Canada's council is describing to the Department of Indian Affairs how the negotiations are going with Ontario. Canada's council reports that Ontario Council, which is Mr. Irving, quote, had made his consent conditional upon the ascertainment of the amount which is to be capitalized for the future after the 31st of December, 1892. It seems to be the desire of both the provinces and the Dominion that instead of having an annual sum payable by the provinces to the Dominion to make good the increased annuities, the annual sum should be capitalized and the Canada account charged with the amount of capitalization as was done in 1867 with reference to the fixed annuities. And Hogg goes on to state that the capitalization has reference only to the Huron Treaty and not to the Superior Treaty. In his opinion, in the case of the Superior Treaty, quote, after 1874, the expenditure has been greater than the revenue. This is likely to continue for many years to come. And then his advice to the Department of Indian Affairs is, I find that the provinces are anxious not only to have the subject matter which is immediately under the jurisdiction of the arbitrators brought to a close, but to have all outstanding matters relating to these treaties finally disposed of. So what Hogg is saying here is that we have the numbers for the period up to the end of 1892, which is in the arbitrators' agreements, setting up the arbitration process. And those numbers have been placed before Ontario and Quebec. There has been some agreement on what numbers to charge against the province of Canada and therefore against the shares as set out in the 1870 award against the accounts of the province of Ontario and the province of Quebec. But as well, Ontario wants to take this opportunity to also provide for a capital sum to cover future payments of an increased annuity in the Robinson Huron Treaty area. And Ontario's consent to all of the numbers for the arrears package is going to be conditional on also reaching an agreement on capitalization for future payments.
And can you remind us, Ms. Jones, how that capitalization idea was introduced by Canada, by whom?
The initial capitalization of what we call a fixed annuity, the the sums that are actually mentioned in the treaty was proposed by the Auditor General for Canada, Langton, in 1868. And that was agreed to as a charge against the Province of Canada account by Ontario and Quebec prior to the 1870 arbitration and the award. And the award itself had a statement about the lands of the province of Ontario, but again, just set out a proportion in which the amount could be charged.
Was
the debt of the
your
province of
question,
Canada.
Ms. Glasser, with respect to who proposed the idea of capitalization again now in 1899 or for the very first time?
On the slide, it had referenced back to the first point, 1867, with reference to the fixed annuities. So I was just having her remind us that it was Mr. Langton that had introduced that idea at that time.
All right, and in your answer here, Ms. Jones, did you say that Ontario said they were ready to settle? Said it two ways: conditional on a capitalization with reference to the Hurons, or conditional on the deal for the future being made? And was capitalization part of that condition?
Yes, yes. The idea was to capitalize an amount. Again, we've seen the numbers for the Huron Treaty proposed by Canada reduce a few times to a number that they think that Ontario and Quebec can be asked to pay for payments into the future for the Robinson-Huron Treaty.
Thank you.
You can go on to slide 107.
These negotiations, but another milepost was reached in the negotiations with the issue of an order of the Board of Arbitrators of the 6th of May, 1899. Again, there's some correspondence leading up to this application for an order. It was application of Council for Canada, Ontario and Quebec consenting that the statements that we've just looked at and that were signed off by Council filed by with the Board of Arbitrators showing the receipts and expenditures, and the statement showing the years in which there was an excess of receipts over expenditures that would allow payments to be made without incurring loss, be declared to be final and conclusive as against all the parties to this arbitration. So in the order, the years in which the statements showed that there was an excess of receipts over expenditures are listed for both the Huron and Superior treaties. So this is not an award per se, it is just an endorsement by the board and a statement that these statements that have been filed with them are to be declared final and conclusive against the parties in the arbitration.
Thank you.
The final and conclusive clause, I believe, arose from a request from Ontario Council, Irving, where he had written to Mr. Hogg, Council for Canada, requesting this kind of an order. Quote, that the statements be declared to be final and conclusive against all the parties to this arbitration.
You call it an endorsement. Unless you correct me, I'm going to call it a consent order.
Sure.
Because it's an application by the parties for an order and it says it's an order.
Yes.
Thank you.
can turn to slide 108.
This is more of the text of this order of the Board of Arbitrators of the 6th of May. The next clause orders that in respect of the amount of the increased annuities payable in any of the said years, which is the years that have been previously enumerated, which there's been an excess of revenues over expenditures, which have not been paid by the Dominion, such amount be charged in the account of the province of Canada on the 31st of December, 1892. This is then a direction on how the amounts will be charged and at what time. It is further ordered that in respect of the increased annuities paid by the Dominion, so that's 1875 and afterwards, to the Dominion since the Union, such payments be charged in the account of the province of Canada in the respective years of payment up to and inclusive of the year 1892. Again, there's some reference back to the earlier awards and orders of the board in 1895 and 1898, which provide instructions as to how these entries should be shown. And then there is a additional clause, and it is further ordered that all admissions and declarations made in this order being made with respect to claims arising out of the said treaties of 1850 are not in any way to prejudice or affect the rights of the parties in any other matter or proceeding. And that last clause arises from a request made by the province of Quebec.
Can you elaborate on that?
We have a letter from Mr. Hogg, which to Irving, which describes this request by Quebec.
Is that JBD tab 1770? And that's in the compendium of demonstrative documents, tab 15. Pardon me, Your Honor. Sorry for the delay. I just realized that we don't have that item in the demonstratives. I'll hand it up if I may.
Sure.
This is a letter dated the 10th of April, 1899, which I believe was referred to by Professor Messamore as I have the origin of one of the clauses in the order, which is attributable to Ontario. This letter explains the origin of another clause in the order, which has arisen from this request by Council for Quebec. I should explain at this time, I haven't said very much about Quebec in my testimony. There's some more information in my report about the position of Quebec from time to time. But in the slides, I haven't said very much about Quebec at all. But Quebec had a number of other issues to do with the province of Canada account and with their own account about which they were concerned at this time. For example, there were some issues surrounding revenues and charges on the Common School Fund and the revenues from land sales relating to that fund. And they had some other specific line items which were not quite of the magnitude of the Common School Fund, but which they did not wish to indicate were finally resolved. So this letter here is from Counsel for Canada, who has been, I suppose, an intermediary between Ontario and Quebec, you could call him, working with Counsel for Quebec on how to create an order regarding the statements for the Robinson treaties. Hogg has written to Mr. Trenholm, Counsel for Quebec, regarding Ontario's request to add a clause in the order making the statements filed final and conclusive. So he reports to Mr. Irving that Mr. Trenholm has some notion that by consenting to the order, he might in some way or another be committing Quebec to something more than the order specifies on its face, and he desires to have a clause added to the following effect. Such consent is not to be in any way directly or indirectly invoked or to have any effect as regards Quebec in any other matter than that of the Indian annuities in question.
So it's without, he wants a without prejudice
Yes,
to anything as between them, any other issue between
any
them.
other issue. Yes, he's not
Except the annuity.
objecting or proposing to reopen the Indian annuities question. He's referring to some other issues which are live in the arbitration and in litigation at this point. That he wants to make sure that by consenting to this one line item in the, as it's going to be part of the accounts of the province of Canada, that he is not taken as giving consent to any of these other unrelated items.
Thank you.
And Mr. Hogg goes on to say, I do not see how the consent and order could have any effect upon Quebec in any other matter than that referred to. And he also says, I do not at the same time see that the clause which Mr. Trenholm decides to have added can affect the finality of the statements for the purposes for which they are filed. In other words, he says, well, but I don't see how the consenting to these statements could affect any other matter that Quebec is concerned about. I also don't see that putting in a clause like this will affect the finality of the actual statements, the matter on which the order is going to be issued.
And do you recall whether you and Professor Mesamore, view this document in the same way with respect to the finality of the statements and the order?
Well, I'm not sure I would want to paraphrase her, but I think she might have read the without prejudice clause in the order as having a broader application, possibly to the acceptance of the statements. And I think this correspondence makes it fairly clear what the intent of that clause actually was. It was not meant to affect the finality of the order as regards the statements.
And ultimately, did Quebec agree?
Yes. So each province, Ontario got their clause about finality and conclusiveness. Quebec got their clause about without prejudice.
We can go to slide 109.
So this is now following the order, and Hogg and Irving, Counsel for Canada and Counsel for Ontario, are exchanging correspondence after the order has been issued, confirming exactly, again, what amounts are going to be charged to the province of Ontario account, a province of Canada account, I should say, and on what dates. Irving writes to Hogg shortly after the order is issued, expressing his opinion that these figures so far, when approved of by Ontario and consent given, would seem to close up the province of Canada account in respect of these Indian annuities. insofar as affected as the arbitration. At the same time, Irving is pressing Canada on the capitalization issues. The rate of interest generally payable in the money market has fallen since 1867 and is now closer to 3% than 5%. So Canada has proposed a capital sum to be charged to the province of Canada for the future annuities that would yield the appropriate amount of money at an interest rate of 3%. Irving says that it should be a capital amount that would yield that amount of money, assuming a 5% return. So Irving is essentially asking that a lower capital sum be charged to the province of Canada. Irving then says to Canada, if you don't agree to having a lower amount of money charged to the province of Canada account, that, quote, it would compel him as representing Ontario to exercise a greater scrutiny as to the number of Indians. So again, Ontario is raising this prospect of, if Ontario is going to be made partially responsible for some of this payment of annuities, that they are going to insist on the right to reopen the pay lists and to give their views on who should or should not be paid Robinson Treaty annuity. We're talking here, of course, about dollar amounts. The dollar amount to be charged to the province of Canada account, which can be higher or lower based on the amount of interest that is assumed, or the dollar amount which would be paid as a result of paying a larger or a smaller number of treaty beneficiaries.
Ms. Jones, can you explain a little bit further how you understand the concern of Ontario about the number of annuitants that may be entitled to a payment affecting the provinces directly?
It affects them directly because it will, again, affect the amount to be capitalized for future payments. We've already seen that those calculations were based on assumptions, averages, a fairly arbitrary number. But the mathematics is number of annuities times difference between $4 and what they would get out of the capital amount that was set aside in 1867.
It's one of only two factors
Right,
in the multiplication
right.
that will arrive at the annual amount necessary
Right.
to pay. So you're either talking about the dollar value or the number of annuitants. And those two numbers multiplied together will give you an amount per year
Right.
that has to be generated by a capital sum. So as I see it, so they're negotiating over what the capital is.
Yes.
And in that set of negotiations, they can talk about the total amount or the interest. And when they can't seem to come to an agreement on either of those, Ontario says, oh, but that other issue that we were negotiating before, we'll bring that back into the discussion.
I
number
think
of
that's
annuitants.
exactly what's happening.
Okay. Can I ask you to just clarify one thing? If I say, when you said, this is on the slide before, Ontario got their clause about finality and conclusiveness.
Yes.
Is it fair to say Quebec got their clause that this finality was specific to the annuities?
Yes.
Is that the way you see it?
Yes.
And you say that may be a difference between you and Professor Messamore?
Again, I'm not sure I want to paraphrase what it was she was trying to say, but it seemed to me that the implication was that that finality and conclusiveness clause might have been intended to apply to the annuities as well.
Thank you. Sorry about that, going back.
John, I'm cognizant of the time.
Is this a good place? Are you finished this slide?
I think we're starting the next slide, so we can break now.
All right. Let's do that. Let me just catch up. Your last statement, Ms. Jones, was, but it seemed to me that the implication was that the finality and conclusiveness clause might have been intended to apply to the annuities as well. That's not what you meant, was it?
Oh, no,
the
I
without
guess
prejudice
without
clause.
prejudice clause, yes.
Okay,
She can explain her interpretation of that document better than I can, but perhaps I'll just take this opportunity to reinforce my interpretation of it. That might
I
be
think
safer.
I've got it. You say
Right.
Quebec got their clause that the finality was specific to the annuities only.
Yes,
Okay,
But important for my question was that without prejudice did not apply to the annuities.
yes, that's my interpretation of it.
okay, let's take a break. An hour? Will an hour do? 12:30, 1:30, we come back? Thank you.
All rise.
Till 1:30.
This court recess until 1:30. Yeah.